Hi everyone, I'm Margo with ACRL. Thanks for joining us today. I am pleased to introduce today's ACRL Presents webcast offered as part of Fair Use, Fair Dealing Week. As a reminder, today's session is being recorded and we'll share the link to the recording shortly after the webcast. Our presenter today is Carla Myers. Carla serves as Assistant Professor and Coordinator of Scholarly Communications for the Miami University Library. Her professional presentations and publications focus on fair use, copyright in the classroom, and library copyright issues. Carla is a presenter for the ACRL Scholarly Communication Roadshow, and she has a BS in psychology from the University of Akron and a master's in library and information science from Kent State University. Thanks for being with us today, Carla, and whenever you're ready, the floor is yours.
Okay, we'll dive right in. Thank you so much for that introduction, and I want to copy the sentiments in the chat. Happy Fair Use, Fair Dealing Week, everybody. I am so excited to be helping celebrate this. It's such an important thing, and I'm excited to be talking with you today about how do we answer fair use questions for our faculty. Margo, I'm not seeing my slides. Oh, there they are. Okay, let's kick on to the next one. So my name is Carla Myers. I'm the coordinator of scholarly communications at the Miami University Libraries. I've been working with copyright for about 15 years right now. It's something I'm very passionate about. And moving on to the next slide, what I would like to discuss with you today in this presentation is first off to provide a very general introduction to the law. That is U.S. copyright law and fair use itself. I want to put forward some considerations for you and your institution as you think about how you might be able to help your faculty with fair use questions. I want to share with you a few methods that are available for conducting consultations with faculty on fair use. And then in the end, I want to share with you some resources and tools that you can utilize to help yourself learn more about the law or fair use or aid your faculty in making fair use determinations. Let's move forward. So kicking off with a very basic introduction of U.S. copyright law, we will go to the next slide. And one of the most important things I think to know is how copyright is secured. So copyright protection exists in original works of authorships, meaning you haven't copied them from somebody else, that are fixed in some format that allow us to perceive it with one of our senses, whether we can see it in front of us, if it's a book, if it's a sculpture, if it's a work of art, or if it's fixed digitally. So if you think about opening up a Microsoft Word document and starting to type and then hitting save, or maybe it's an MP3 music file, or maybe it's a digital video file, or maybe it's a DVD that we're putting into the player. As long as it is original and fixed, it instantly has that copyright protection. A few misconceptions: the copyright notice, so the little C in the circle symbol with the date and name, that is no longer required for protection. I will still hear from my faculty and students sometimes, well, there was no copyright notice on this, so there's no copyright protection, and that's not true. Registration is also not required. Sometimes faculty will say to me, well, I never registered my work, so I don't have copyright protection in it, and that's not true either. You instantly have that protection once you have the original work and it's fixed. That's all it takes. We'll go to the next slide, please, Margo. So these are the different types of works that are eligible for copyright protection. For the sake of time, I don't want to sit here and read all of this off the slide to you, but as you can see, there are many types of works that are eligible for copyright protection, and we will go to the next slide. So who owns copyright? Generally, it's going to be the person who creates the work. There are works of joint authorship, and we see this all the time in academia. If you think about a group of students working together to prepare a report, to prepare a PowerPoint presentation, they are all collaborating to create a work that's eligible for copyright protection, and as long as they all contribute copyrightable content to that work, they will equally share in the copyright in it. We see this very often with our faculty members as well. Faculty collaborate together on research or teaching, and those could be considered joint works of authorship as well. And then there are also those work made for hire situations, which occur one of two ways. An employee creates a work within the scope of their employment, or somebody is commissioned to create a copyrightable work. In these situations, the copyright may end up resting with the employer or the person who commissioned the work. One piece of advice I always like to give out is if you are ever being hired to create a work that's eligible for copyright protection, make sure you have a conversation with the person who is hiring or commissioning you to do that in regards to who is going to own the copyright in the final product. And let's go to the next slide, please, Margo. So how long does copyright last? Generally, it lasts a long time. For those works that are created by a single author, the duration of copyright is that author's life plus 70 years. For those works of joint authorship, it's the duration of the life of the last surviving author plus 70 years. And for those works made for hire, copyright lasts for 95 years from when it is published or 120 years from when it was created, whichever comes first. Let's go to the next slide, please. So once you create a work that's eligible for copyright protection, the law grants you certain specific rights. The first right is to make a copy of a work. This is any type of copy, a print copy, an electronic copy, a digital copy, a photocopy. The person who owns the copyright in the work gets to decide what type of copies are made. They also get to decide how those works are going to be distributed or shared with others. Sometimes this is for free, sometimes it's for a fee, sometimes it's being distributed in a physical format, sometimes it's being distributed in a digital format. The rights holder gets to decide how those works are distributed. They also get to have some say over derivative works. So derivative works are retelling or re-expressing the original work in a different way. My favorite example of derivative works is Harry Potter. We have the original novels, and then we have the translations. We have the graphic novel versions. We have the movie versions. We have the audiobook version. All of those different versions express the original in a new way. Those are considered derivative, and J.K. Rowling, as the rights holder, got to have some say in how those derivatives were made. Other rights include the right to display or show a copyrighted work in public, and also the right to perform, so act out, to recite, to play a movie or to play music in a public area. As you go through my presentation, you might see these notes about Learn More. These are just resources you can turn to learn more about a particular topic. The one I've included here is a Copyright Basics circular put out by the U.S. Copyright Office. I think it's so important for all librarians to have a foundational knowledge of the basics of U.S. copyright law, because it's going to help you better recognize when you're working with a copyrighted work, and it's also going to give you a better context for working with some of the exceptions, like fair use, that we're going to cover today. So I would encourage you to take a look at that basic circular. It's very helpful. And let's move on to the next slide, please. So copyright infringement. Copyright infringement occurs when we take advantage of one of the rights granted to creators of copyrightable work under the law. So when we make copies of work, when we distribute those works, when we make derivative works. When I first started learning about U.S. copyright law and learning what infringement is, my reaction was yikes, because on a college campus, this happens every day. It happens every hour. It happens every minute. We work with faculty who want to make copies of works, who want to distribute copies of works, either physically to students in class or maybe online through the content management system. We have students making derivative works. We have people making public performances and public displays in the classroom or other areas on campus. So when I first started learning about copyright, this made me a little bit nervous. But fortunately, exceptions have been written into U.S. copyright law. And these exceptions are reflections of Congress saying, you know what? There's times where people need to reuse copyrighted works in certain situations for certain purposes, and it may not be practical or reasonable or feasible for them to get permission or a license to do so. And as such, we have these exceptions to consider for various reuse of works. And one of those exceptions is the fair use exception found in U.S. copyright law. Let's go to the next slide, please. So it's located in Section 107 of the law, and if you want to pop onto the next slide. Here is the language of the Fair Use Statute. This is fairly short as far as the Fair Use Statute goes. Again, I don't want to read this whole entire thing to you. Instead, what I'm going to do is very briefly review the 4 factors of the Fair Use Statute. You can see those right there in the center, and working through these 4 factors is how you determine if your particular use might be considered fair or infringing. Let's go to the next slide, please. So the first factor is looking at what is the purpose of your particular use, or what is the purpose of the faculty member's use? Why do they wish to reuse this particular work? Is it for teaching, research, or scholarship at a nonprofit educational institution? Are they providing criticism or commentary on the work? Is the use a commercial use? One common misconception that I encounter frequently is because there might be a commercial use, because I might be making money off this, I can't consider fair use, and that's not true. We have plenty of court cases that show us that commercial uses can be considered fair use. It does mean you need to think a little bit more carefully about your application of fair use, but commercial uses can be considered. And then more frequently, what we're seeing in the courts is considerations of transformative uses. And transformative uses ask, have you taken the original work and transformed it into something new by adding some type of new expression or meaning to it? I think a good example of transformative uses is parodies, taking a very popular or well-known work and providing criticism or commentary or poking fun at it. One of my favorite examples is Weird Al and his parodies. Certainly, if you've ever listened to any of those, you can see that he's having fun and poking fun at the original works. So transformative uses are highly, highly favored by the courts as well. If you want to learn more about transformative uses, which I would encourage you to do, I would suggest reading Toward a Fair Use Standard by Judge Pierre Laval. He is one of the people who kind of pioneered this idea of transformative use, and it's a really great work talking more about it. Let's go to the next slide, please. So the second factor takes a look at the nature of the work. What is the nature of the work that you are copying? Is it something like a factual textbook or a scholarly monograph? Is it a work of nonfiction? Is it a work of fiction? Is it highly creative? Is it the latest crazy Stephen King book? Is it the latest Peter Jackson movie with 10,000 special effects every single hour? The more creative a work is, the more copyright protection it tends to have under the law. Again, just because a work is really, really creative does not mean it cannot be considered for use under fair use. It just means you might have to think about your analysis a little bit more carefully. Something else to think about is, has the work already been published or is the work unpublished? Generally, where rights holders make the most money is when their work is first shared with the public, or they may have specific reasons why they didn't want a particular work published. And the courts tend to put some favor on the right of first publication granted to the rights holder. Again, this doesn't mean because a work is unpublished, it can't be considered fair use. You just have to think a little bit more carefully about your particular use. Let's go to the next slide, please. So the third factor, the factor that everybody loves to hate. You can see here that I have repeated the text from the Fair Use Statute because I think this is so critically important. Most of the misconceptions surrounding fair use, I think, are tied to this factor. So the third factor of fair use says that you need to consider the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And underneath that, I put one of my favorite quotes from a famous copyright lawsuit, in which the judge said there are no absolute rules as to how much of a copyrighted work can be copied and still be considered fair use. The third factor requires that you think about quantity and quality. How much you're using and how is that portion in relation to the whole entire work. I always encourage people to consider the amount you need to serve the purpose of your particular use in relation to the whole. Is it a small portion, whereas with something like a picture, it's very hard to give somebody half a picture. Generally with pictures, you have to reuse the whole work. And one thing I tell faculty is if you're on the fence about this a little bit, this is a judgment call. And if your use of a work is ever questioned by a rights holder, it's one you need to be prepared to justify. We'll talk about this a little bit more down the road, but making sure that they understand the importance of using the amount needed, keeping in mind that sometimes that can be the whole entire work and other times it's smaller parts of works. If we can move on to the next slide, please. So the fourth factor of fair use is the effect on the market. And one of the things to take a look at here is your use of a particular work resulting in lost revenue for the rights holder, or could it replace the sale of an original work? Again, going back to my Weird Al example, I think it's very unlikely that somebody going to iTunes or Amazon looking to buy Coolio's Gangster's Paradise is going to end up buying Weird Al's Amish Paradise instead. Even though the background music to both is very similar, if you listen to them, they are two completely different songs. So it's not likely that one would substitute for the other. Something else I encourage people to think about is kind of the counter side of that. Could your use under fair use help promote the market for the original? In some way that you're using it, could you actually encourage people to go back to the original item and increase the market for it? So let's move on to the next slide, please. So it's so confusing. When I first started working with fair use, I found it very confusing. Many of the patrons that I work with find it to be confusing. And one of the issues I run into as a copyright librarian is oftentimes people come to me and they have a fair use question and they're looking for this very simple yes or no answer. And sometimes I understand what they're looking for. They're busy faculty. They don't necessarily want to go through the whole entire analysis. They're looking for a quick and no yes or no answer. And those aren't always readily available. Usually you can get to yes or no, but sometimes not as quickly as what the patron is looking for. And don't let that discourage you. That means that you're being thorough and trying to make a careful analysis. The fair use statute was deliberately created to be vague, which is good because that means it's flexible for all the different situations we might encounter. One very important thing to keep in mind is that each application of fair use should be made on a case-by-case basis. I've spent much of my career working in libraries, in library circulation departments, and working with course reserve systems. And for any other course reserve managers out there, you will know what I mean when I say the faculty member walks in with a stack of 20 readings and says, I need these all put on electronic reserve and it's all fair use. And in those situations, for me, it's taking a step back and saying, I'm happy to help you, but let's go through these one by one and make sure we're taking a look at fair use for each individual reading and not making a group decision. Let's go on to the next slide, please. So how do you answer questions about fair use when faculty approach you with them? Let's move on to the next slide. So I think the first thing you want to think about is what types of consultations will you provide? And there's some things you need to consider as part of this. So what types of services is your institution prepared to offer? And when you're asking yourself this question, I would challenge you to really think about your institution's value and mission. I know some librarians get a little bit concerned when faculty keep coming to the library with their copyright questions. But if you think about it, it kind of makes sense. We are seen as the go-to resource for quality information on the college campus. So when they're looking for quality information about copyright, they want to come to the library to see if they can get assistance from librarians who they respect for their integrity and professionalism. So instead of shying away from these questions, thinking about them within the scope of all the other information services we offer. Also think a little bit about risk management. I know sometimes I've worked with libraries or librarians and they say, oh, but the risk, the legal risk, what if we get in trouble for practicing the law? What if we get in trouble for something we say? And I would say, you know, sometimes you do have to think carefully about what you're saying or the information you're sharing. But risk management goes both ways. There is always a little legal liability in lots of things librarians do. But in providing quality information to your campus community, when your faculty come to you looking for quality information on fair use, you can actually be helping to mitigate risk for your institution by sharing with them quality information about the law. If they don't know where to go to find that quality information, they might look online, and my fellow copyright librarians listening in today can help you understand how much bad copyright information is online. So if they find some of that bad information about fair use and follow that instead of getting the good information from you from the librarian, there might actually be a little bit more risk. So instead of thinking about in terms of risk management, oh no, this is scary, we could get ourselves in trouble, think about how you may actually be able to help mitigate risk for your institution by providing these consultations. Something else to think about is, what are you comfortable with? Knowledge of the law, of U.S. copyright law or of fair use, doesn't necessarily always translate into feeling most comfortable in helping faculty with their fair use questions. If you find yourself in the position of being designated as a copyright librarian or the copyright guru, and you don't quite feel comfortable speaking about the law or sharing information with faculty yet, what I would encourage you to do is speak to your supervisor. Ask them to support you in getting as much training as possible from reputable resources so that you do become more comfortable with the law and with providing and sharing information with faculty. And then think about what types of consultations you want to actually provide. I've seen 3 primary types of consultations, and we're going to take a little bit closer look at each of these if we can move on to the next slide. So the first type of consultation some libraries choose to provide is referral to information. And this is exactly what it sounds like. If you have ever worked in a law library, if you know anybody who works in a law library, a lot of the reference librarians working behind the desk in law libraries have their JD, they're attorneys. That doesn't mean that they can provide legal advice to the patrons who are walking in the front door. Instead, what they do is they use their knowledge of the law to direct patrons to information about the law. So they come in with a question about a particular area of the law. They can say, let me help you pull up that area of the law. Let me help you find quality information online. Let me help you find a book that we have on this particular topic. The biggest thing with providing these types of consultation services is making sure you are referring the patron to quality information. Again, there is so much bad information about copyright out there on the web, and sometimes it can be tricky to discern the bad information from the good. As we get toward the end of the presentation, I am going to have links to some of my favorite resources that provide quality information about the law, so you can start from there. When it comes to fair use, we are also later going to take a look at some fair use tools that you may be able to direct faculty to help them make their own fair use determination. So this first type of consultation that you or your institution can provide is a mere referral to information and then allow the patron to make their own determination. If we can move on to the next slide. So another type of service you can provide is a referral to somebody else. Do you have a copyright librarian on staff? If so, when patrons approach the desk with questions, can you as a reference librarian say, that's a great copyright question, let me put you in contact with our copyright librarian. Sometimes a university might have designated copyright gurus or gurus. Here I'm kind of thinking about the Copyright First Responders program out of Harvard University. This program was founded by Cal Courtney, who is the copyright librarian for Harvard, and it's a pretty amazing program. He trains people in each department to be able to answer basic questions about U.S. copyright law. So there is somebody within many, many departments at Harvard who their faculty colleagues can turn to ask basic questions about the law. And then when more advanced questions come up, they can pass those on to Kyle to utilize his knowledge and expertise. But think about, is there somebody on campus or maybe outside your library who's knowledgeable about the law who you might be able to direct the person to as well? Many higher education institutions have an Office of General Counsel on campus, staffed by attorneys who are there to protect the university's interest and help with legal questions and considerations. Sometimes this office is on campus, and sometimes university contract with law firms within the community. But I have yet to find a university that does not have an Office of General Counsel or an associated attorney in some capacity. And this person can be a resource as well. They are an attorney, they are trained in the law, and if they're not the most familiar with U.S. copyright law, they have the skills and knowledge to go out and find the law and learn more about it and provide assistance as well. So if you are going to do a referral to somebody else, figure out who is the best person that you can refer your faculty patrons to, and then how can a faculty member get a hold of them? What is the preferred way of providing these consultations? Is it by phone? Is it by email? Is it on one-on-one appointments? And then what type of services can this particular person provide? I know different copyright librarians provide different services. Some do consultation, some help with permissions requests, some will help with reviewing publication agreements to help faculty understand their rights. So getting an idea of what types of services they can provide, so when the faculty patron asks a question, you can let them know, here's the person who can help you out, here's the services they provide, here's contact information for you to get a hold of them. And let's skip on to the next slide, please. So the third type of thing you can do is direct consultations. And I see these happen on college campuses one of two ways. The first is in assisting the patron in working through the 4 factors of fair use, helping them but letting them make the final determination, or answering their question. When they come to you and say, hey, is this a fair use? Providing an answer, I think this could be considered a fair use, or no, I don't think this falls underneath the scope of fair use. And now I want to take a little bit of an in-depth look at how this happens. If we can move on to the next slide. So when faculty members come to me and they have a question, the first thing I say is talk to me. I want to get as much relevant information as I possibly can about their particular situation so I can provide the best answer to them. We'll take a look at all of this a little bit more in depth if we can move to the next slide. So my first question is, what are you looking to reuse? And the reason I ask this is when you're providing a copyright consultation or dealing with a copyright issue, the first question you should always ask yourself is the work in front of us, is this the work that they want to reuse? Is this even protected by copyright? Is this work in the public domain? Is it in the public domain because its copyright has expired? It no longer has copyright protection. Or is the work in the public domain because it was created by an employee of the U.S. government? An example here could be a photograph from NASA. Works created by employees of the U.S. government acting within the scope of their job are in the public domain, meaning that they do not have copyright protection and are free for people to reuse. So if the work in front of us is a public domain work, we don't even have to worry about fair use. The work no longer has copyright protection or never had copyright protection. The faculty member can use it as they wish. Sometimes works faculty are interested in reusing have some type of license attached to it. For example, an open access license or Creative Commons license. If you're not too familiar with these terms, that's okay. We will go into them a little bit more in depth later in the presentation. But if there is a license tied to that work, you may need to consider the license rather than considering fair use. So if the faculty member is telling you about the work they wish to reuse, it's not a public domain work. It is not an open access or Creative Commons work. My next question is, where did you get this? I'm trying to find out who owns the copyright in the work. I provided a consultation a while back, and my faculty member was interested in using some pictures and a PowerPoint presentation she was going to give at a conference. And it turned out the pictures she was interested in using were pictures that she and her husband had taken while they were on a trip. It was a trip taking a look, well, I think it was a combination research and vacation. But she was visiting a city. She had taken lots of pictures of historical landmarks, and she wanted to use those pictures in her PowerPoint presentation. And I explained any pictures she took, she owned the copyright in, therefore she could use them how she wished. If her husband took the photograph, her husband would own the copyright in the photographs, and she could get permission from him to reuse. But because she owned the copyright, we could work within the scope of that. If it's not a public domain work, if it's not an open access or Creative Commons work, if the work is protected by copyright and that copyright is owned by somebody else, that's when we want to start to consider fair use as an option.
Hi, everybody. Just bear with us one moment. Thanks so much. We'll be back shortly. Um, oh, I was talking, but I wasn't talking, but now I am. Thanks.
So thanks everybody for sticking in there, and apologies for the technical difficulties. I will pick up where I left off. Asking the faculty, what is the work that you're looking to reuse? And the reason we ask this question is the first thing you want to figure out in any type of copyright consultation is this work in question, the one that's going to be used, actually protected by copyright? That's because the work could be in the public domain. It could be that the work's copyright has expired. Right now, works published in the United States prior to 1923 no longer have copyright protection. Their span of copyright has simply run out. They're in the public domain and they're free for anybody to use. They could also be a work created by the U.S. federal government. Those works are in the public domain as well. So if you think about some of NASA's photographs, those can be freely reused. And the reason you want to ask about this is if the work is in public domain and has no copyright protection, you don't even have to think about fair use. The faculty can go ahead and reuse it however they wish. Something else I'm looking for when I ask this question is there some type of license tied to the particular work that they're looking to use? So for example, an open access license or a Creative Commons license. If you're not too familiar with those terms, don't worry. We're going to look at them a little bit more in depth in the presentation. But if it is an open access or Creative Commons work, or maybe even a work that has been licensed by the library for certain types of use, some of the items in our collection, then you may need to work within the scope of that particular license, and fair use might not be an option in that particular situation. Another question I ask, if it's not a public domain work, if it's not an open access or Creative Commons work, is who owns the copyright in this particular work? A lot of times it's going to be somebody else. Someone else created the work. But every now and then they're asking a question about a work they created. A while back I had a consultation with a faculty member who brought me a series of photos that they were looking to incorporate into a PowerPoint presentation. And I said, oh, where did you get these photos from? And she said, well, my husband and I toured this city. We took photographs of the landmarks, the historical sites. So these are our photographs. My husband and I took them. Well, the great thing was at that point, the photographs that she took, she owned the copyright in. She could reuse however she wished. And the photographs that her husband took, he owned the copyright in. So I said, go get permission from your husband to reuse them. So we didn't have to think about fair use because she owned the copyrights in some of the work she was looking to use. But if the situation is they're looking to reuse somebody else's work, then part of what I ask during this phase of the consultation is how much of the work are you looking to reuse? Is it the whole entire thing, or is it just a small portion of it? If we can pop on to the next slide. And then after I ask, what is the work that you're looking to reuse, I ask, how are you looking to reuse that work? Is it in a face-to-face classroom setting? Is it part of online education tied to this university? Are you looking at making photocopies and distributing those? Were you thinking about just linking to these particular works? Is it part of publication? Are you going to include this in a book or a journal article? Is it just for your own personal use? Are you asking me this out of your own personal curiosity? Is it going to be posted behind a password-protected university content management system? Is it going to be posted to the university website? Is it going to be posted to a public website? If it's a flyer or a poster, is it going to be displayed here on campus? Or are you going to put up copies all over town? So getting as much information as you can about how they are looking to reuse the work. And then if we can move on to the next slide, please. I like to ask, can you think of anything else I should know about this situation? Anything else they want to share? Thinking about, can you spot any holes in the information they're sharing with you? Is there any type of scenario or something going on that they might not have thought of? And I hate to say this, but I feel like I have to be prudent in saying this. Does anything sound suspicious? I will say that 99% of the people that I work with come to me and ask me questions because they want to be in compliance with the law. They're very eager to be in compliance. But every now and then, you get somebody who may not have the best of intentions. I remember one consultation I did once when a faculty came to me and said, the faculty member came to me and said, oh, I'm looking to reuse part of a book for course instruction. And I said, okay, what type of book? Can you tell me about the book? And she said, well, it's a scholarly book. And I said, oh, can you tell me a little bit more? She's like, well, it's the class textbook. And I said, okay, the class textbook, something students would normally be required to buy. You want to make copies and share that with the students. How much are you looking to share? And she said, oh, well, some of it. Well, what's some of it? Can you tell me a little bit more? Well, maybe it would be a significant part. Well, what do you consider to be a significant part? And she said, well, I'm not planning on scanning and sharing the index, and I'm not planning on scanning and sharing the table of contents, so it's not the whole entire thing. But I really kind of had to pry out of her all of the facts of the situation. And once I found that what she was looking to do was basically scan and make the whole textbook available online, at that point, we had to shift our conversation into how that particular scenario most likely would not have been viewed as a fair use. So sometimes you have to kind of pry the information out of the faculty member, but don't be afraid to do that. You want to work with the most comprehensive information as possible. So if we can move on to the next slide, please. So you've asked them, what are you looking to reuse? How are you looking to reuse it? And at this point in the consultation, after I've gathered all that information, I pause and think for a few seconds. So the first item here, is fair use even a consideration for this particular situation? Under some circumstances, fair use might not necessarily be an option. Either right away you see that this is beyond the scope of fair use, or some type of license may control how the work that can be used, and you have to act within the scope of that license. Another question to ask yourself is fair use the best exception for this particular situation? There are many other exceptions written to U.S. copyright law. There's the exception in 110.1 that has to do with face-to-face course instruction. There's the exception in 110.2 that has to do with online distance education. There's an exception in section 121 that has to do with creating accessible copies for library patrons. Maybe fair use is the best fit, maybe it's not. So stop and think about if you want to move forward with fair use, or maybe if you want to take a look at one of those other exceptions. If your situation falls under the first or second one here, fair use is not a consideration or it might not be the best exception, then you want to skip ahead to the other options, and we'll get ahead to those in a few minutes. But if you're thinking, you know what, I think fair use could be considered here, then this is when I proceed on to step 2. And if we can move on to the next slide, please. So step 2, this is where you start to work through the 4 factors of fair use. And again, depending on the type of consultation you are offering, either helping the faculty member work through these 4 factors and come to their own determination, or working through these on your own and making a recommendation on how best for the faculty to proceed. If we can move on to the next slide, please. There are tools to help you do this. These tools are wonderful resources. If we can move on to the next slide. So a little bit about these tools. These tools only work if the user is completely honest in using them. What I tell faculty is be completely honest. I need to know the facts of the situation. This tool only works if you're honest. And you know, if we use this tool and in the end we come to the determination that what you want to do might not be considered a fair use, that is okay. There are other options that we consider other exceptions, other routes that we can take. What I tell my faculty is it is my responsibility to help you find a legal way to do what you want to do. Sometimes that's fair use, sometimes that's other options available to us under the law. So if fair use doesn't work out, that's okay, but being honest in this tool will help you make a good determination. Especially when you're dealing with a tricky or a high-risk fair use situation, I either keep a copy of the fair use checklist myself, or I encourage the faculty member to retain a copy for their own records. First off, this is a record of the fair use determination that they made, and should their use ever come into question by the rights holder, they could pull out that fair use checklist and use that to show the court how they came to the decision that they did come to. So be honest when using these, and keep a copy is always recommended. If we can move on to the next slide. So this is one of the first tools, the ALA Fair Use Evaluator. You will see the link there. And the reason I like this tool is you will see that bottom gray box says learn more about fair use. So if the faculty member wants to make the determination on their own, or if they're new to fair use, you can refer them to this tool, and they can use that bottom gray box, the one portion of this evaluator, to learn more about the fair use exception. The top gray box on the right-hand side says make a fair use evaluation. As you go into that part of the system, it's going to take you through each factor. It will give you examples of considerations that are likely to favor fair use or that might oppose fair use. There's a text box where you can enter information in. And at the end, you can have a PDF copy of your analysis sent to you for your records. So I really like this tool because of the educational component it has, and also I like the way it's interactive and engages you as you're making the evaluation. If we can move on to the next slide. This is the fair use checklist developed by Dr. Kenneth Cruz. He created this while he was working at Columbia University. And what you can see here is the 4 factors of fair use. And I know the writing's a little small, so I apologize for that. But what it is under each one is examples of things that favor fair use and examples of situations or things that oppose fair use. If we can go on to the next slide. This is the University of Minnesota's Thinking Through Fair Use. And basically what they did is take Dr. Cruz's checklist and make an online digital version of it, which was completely fine because he licensed it as a Creative Commons work. One important thing to keep in mind with these particular checklists is how you do not want to use them is check boxes and then count up to see which side has the most boxes and say, okay, there was the most check marks on weighing against fair use, so it's obviously not a fair use. Or there were the most check marks on the side of favoring fair use, therefore this obviously is a fair use. That is not necessarily how fair use decisions work. Sometimes you can have 3 factors that are opposing fair use, but one of the factors so significantly weighs in favor of fair use that it's still considered a fair use, and vice versa. Instead, what I encourage people to do with these checklists is think of them as a tool for situations and considerations that you should be bringing into your fair use analysis, and check them off as you think about each one and use that space to write your thoughts about that particular factor. That is how I find these are most comprehensive and useful when I'm working through fair use or helping with a consultation. If we can move on to the next slide, please. So, as I said before, it's not necessarily easy. Patrons sometimes just want a straight yes or no answer, and they're like, what's this checklist? Do I really have to do it? Sometimes a no answer is easy. Sometimes a yes answer is easy. The final answer is very subjective to each individual situation before you. And one thing to think about when you're providing these consultations to faculty or helping them with questions is, what are those low risk scenarios and what are higher risk scenarios? So for example, if a faculty member came to me and said, I am writing a book on a particular topic and I am looking to quote somebody else using a few sentences from this person and a few sentences from that person. Is that a fair use? And I would say to them, well, technically you should be thinking about fair use within the scope of each and every quote, but that generally quoting is going to be a low risk behavior within the context that they put before me. Quoting is part of a scholarly book. I am not in any way saying that is always going to be considered fair use, but quoting here, quoting there, it's an educational purpose. You're reusing small parts of the book. It's the generally accepted practice. That is a lower risk scenario as far as being sued for something, as versus a higher risk scenario where maybe the faculty member is saying, I've collected all these photographs from historical locations all over the world throughout my career, and now I want to digitize these and put them all online. You certainly can consider fair use in that situation, but there's a little bit more risk involved with making those publicly available on the web and a general description like that. So with those low risk scenarios, it might be a little bit easier to get to that yes or no answer as versus the high risk scenarios where you might have to do a little bit more analysis and work. One thing to take a look at is legal precedent. The copyright cases that we've seen in the court. Is there a court case that's similar to what's going on in the scenario in front of you that you might be able to consider the precedent set by that case? And then something else I would encourage you to consider is the Code of Best Practices and Fair Use for Academic and Research Libraries. This was developed by ACRL in partnership with librarians, and basically what happened is the leaders of this project went around and talked to academic librarians about how they utilize fair use in the day-to-day goings-on of their job and the ways they engage with their patrons and within the scope of the library services they offer. And they drafted them into this particular document. Last year I had the wonderful pleasure of speaking with Peter Yazzie, who was instrumental in developing this document. And he shared something with me that I want to share with you because I felt it was really significant at the time. And I'm ad-libbing a little bit, but basically what he said is that to date, and this was in 2017, I don't think anything has changed then, no library or librarian has been sued for utilizing fair use within the scope of the Code of Best Practices. And he went on to say, I want to reiterate that no librarian or no library has been sued for utilizing fair use within the scope of these best practices. He said, I'm not saying no librarian has ever been sued and won in court. I'm saying no librarian has been sued for utilizing fair use within the scope of this document. And he said, I think the reason that that is the case is because most attorneys for rights holders who looked at the Code of Best Practices and said, here are what librarians were doing, would see this as a very reasonable interpretation of the law and might realize that they might not necessarily be successful in pursuing a library or a librarian in court in regards to the practices laid out there. Now, I know he was not saying, and I am not saying, that if you utilize this Code of Best Practices that you will never get sued. I don't think anybody would ever tell you, or at least a good copyright librarian or a good attorney will tell you you're never going to get sued if you do X. But instead, I think the point that he was trying to make that really resonated with me is this Code of Best Practices is a reasonable, practical interpretation of fair use, how many libraries and librarians interpret that, and it is a good place for you to start if you are feeling some uncertainty in regards to the application of the law. If we can move on to the next slide, please. So avoiding providing legal advice. I know this is something that people get a little bit nervous about. So the way you avoid providing legal advice is providing information rather than providing an interpretation of the law. I talked a little bit earlier about working in a law library and directing patrons to information and resources on the law as versus interpreting the law. And I can tell you, even when I'm doing a fair use consultation, as we're working through the 4 factors of fair use, or as they are asking for my feedback on a situation, what I generally end up saying is, I think a strong fair use could be made for what you wish to do here. I'm not promising or guaranteeing them that what they are doing would be considered a fair use, because ultimately only a judge or a jury can really make that call. Instead, what I'm trying to say there is that if you are ever questioned by the rights holder, I think a strong case can be made in regards to fair use. Something you might want to think about is if it's a particularly tricky question or if it's a question that you think may have some high risk to it, who is going to make the final call in that situation? Are you comfortable making that call as the copyright librarian or the copyright guru? Is there maybe somebody higher up in library administration who you might want to consult with? Or for those more advanced questions or those situations that might have a little bit more legal risk, could you partner up with somebody in your Office of General Counsel to provide an answer to that particular patron's question? Think about your institution's copyright policies and how those might come into play here. And another great resource, the University of South Carolina School of Law has some great information for librarians on how to help with legal questions without providing legal advice. If we can move on to the next question, please. The next slide, please. So getting through the consultation, my recommendations, ask lots of questions. Like any reference interview, try to make your patron feel as comfortable as possible in sharing information with you. After you've gotten as much information as you can from them regarding the situation, determine if one of the tools might be helpful for you. Every now and then, this doesn't happen too often. Out of all the copyright consultations I've done, I think I can still count on 2 hands the number of people who have gotten angry with me at the conclusion of the consultation. And that's usually because you were not able to provide the answer they were looking for. They were hoping for a quick and easy yes answer, and your response is, you know, I'm concerned. What you want to do? I really feel that it might not fall within the scope of fair use. In those situations, what I try to do is offer other options to them. It might not necessarily be fair use, but we might be able to utilize one of these other exceptions. We might be able to go get permission for your use. We might be able to get a license for your use. Every now and then, I think I've had 2 or 3 of these in my career, you get the really, really angry patron. The one who says that, well, I don't care what you say. I'm going to go do this anyway. And in those situations, it's just helpful to have a game plan to say, you know, let me put you in touch with my supervisor. They can provide you additional information. Or sometimes what I do in those situations is I say, you know, I'm so sorry I was not able to give you the answer you were looking for. I'll send you a follow-up email with some additional information for you to consider later. And I do that. I send them an email. I recap our conversation. Here's the scenario you described to me. Here's why I feel like this does not fall within the scope of fair use. Here's some other options for you to consider, and please remember I'm here to help you with this if you have any further questions down the line. I just try to leave those situations as positive as I can and send them that follow-up information, so if they've had a little time to cool off afterwards, they can go back and reflect on that information. If we can move on to the next slide. So a lot of times frustration comes from these common misconceptions that we very often hear about copyright law. Some of them, if it's on the internet, I can use it however I want. We know that's not true. If it's an educational use, I can do anything I want. Educational uses are favored under fair use, but that doesn't mean they're always a fair use. One I hear very often is, but I'm providing a citation to the work. So if I cite the work, I don't have to worry about copyright infringement. If you look back through the fair use statute, there's nothing in there that talks about citation. So merely providing citation does not make it a fair use or does not negate copyright infringement. And then skipping ahead a little bit for the sake of time, those arbitrary limits. These are the bane of my existence, and hopefully you have all heard them at some time, and hopefully you disregarded them. So things like using 10% of a work is okay, or using one chapter from a book, using 30 seconds from a song, using 3 minutes from a film. I've heard using 5 pictures is fair use, using 9 articles is fair use. Another common misconception is that it's only fair use the first semester. In subsequent semesters, you have to license a use, and that is untrue as well. An important thing to know about these arbitrary limits is they are just that. They are arbitrary, they are made up, they hold no force of law, and most importantly, they provide no safe harbor to you, your library, your institution, or the faculty member for abiding by them. We have seen fair use cases where people have used less than one chapter or less than 10% of the book and have been sued for copyright infringement or found guilty of copyright infringement. So when you hear these arbitrary limits, please disregard them. And there's a great article with a link to there that you can use to learn more about the fallacy of these particular limits or guidelines and the best way to apply the law. So before I move on to the next slide, I want to check with our host. I know because of our technical difficulties, we are running out of time. I do have a little bit more to talk about, but if people have to leave in a few minutes, I do want to put forward the opportunity to answer some questions. So I can either continue on with my presentation and then stay a little bit late and answer questions at the end, or we can go to questions right now. I will leave that to our host on how best to move forward.
This is Margot, and if it's okay with Sophie in terms of the meeting room, I propose that we add about 10 minutes on to kind of make up for the time lost. So you can continue through with your slides, and then we'll switch to Q&A shortly.
Okay, sounds good. So let's move on to that next slide, please. So other options. A couple times during this presentation, I've said, think about those other options. Think about those other options. Well, now we're going to talk about those other options. If we can move on to the next slide, please. So the other options include other exceptions. So Section 108, which is for libraries and archives, Section 110.1, which takes a look at the use of copyright resources in face-to-face teaching. Section 110.2, the Teach Act, which takes a look at how copyrighted resources can be shared in an online environment. Section 121, which takes a look at how accessible copies can be made for those patrons with disabilities. So if you work through that fair use analysis and you're like, I don't think this is necessarily a fair use, first think about these other exceptions and could they be a possible way for the faculty member to do what they wish to do within the scope of these exceptions. If we can move on to the next slide. Another option is using public domain works. We've already talked about this a little bit. So works that were published in the U.S. prior to January 1st, 1923 are in the public domain, as are many works created by employees of the U.S. federal government acting within the scope of their job responsibilities. Say that you have a faculty member who is looking for a particular picture of something. Can you go find a public domain picture that is comparable? Or can you go find a comparable picture that was created by an employee of the U.S. federal government? So that it's a public domain work and they're free to reuse that work and not have to worry about fair use or utilizing one of the other exceptions. Another resource for you is the digital copyright slider. This was created by the American Library Association as well. And you can plug in the year that the work was created, and it will let you know what the copyright rules were at that time in regards to securing copyright and what considerations you might have in regards to that work being a public domain work. If we can go on to the next slide. Another option is Creative Commons works. So Creative Commons works are works created by people that have copyright protection, but that they are comfortable sharing with the public so long as they reuse them under certain terms. And these are the licenses you see associated with Creative Commons works. So CC BY, that means you are free to reuse my work as long as you give me attribution and credit for my particular work. CC BY SA, SA stands for share alike, which means you are free to reuse my work as long as if you make changes to the work, you share alike. You license your new work under similar terms. CC BY ND, the ND stands for no derivatives. That means you can share my work with other people, but if you want to make one of those derivatives, please talk to me about that first. So for example, if you are in a book group and you find a really great short story online and you see that it's licensed CC BY ND, you could print off copies of that short story and hand it out to people in your book group to read and discuss. Say you are also a teacher and you think about, wow, this might make a really great play for my drama class. Well, making a script or a dramatic version of a short story would be considered a derivative work. So before you did that, you might want to ask the person for permission. CC BY NC, the NC stands for non-commercial. That means you can reuse the work as long as you are not making money directly off its use. And then the last two are kind of a mix and match of all of those above. So just to give you an example here, I have a friend, Joel, who does deep space photography. He goes out into the middle of nowhere where it's pitch black dark, and he has these amazing telescopes that he hooks up to his computer, and he takes pictures of planets and galaxies. He does amazing work. He has been published in National Geographic. NASA has used some of his photographs. The BBC has used some of his photographs. He's that good. This is his hobby. This is his passion, and he shares his photographs online under a CC BY NC license. So CC BY, give him credit and have a non-commercial purpose. So when the BBC or National Geographic reached out to include his photographs in their magazines, that was a commercial purpose. They were printing them to help sell copies of the magazine. So they reached out to get his permission. But other people could post them on their own website, print them off, and hang them on their wall. And those are not commercial pursuits. Those are just for their own personal use. And that's completely fine as long as they give him credit for it. The Creative Commons, it's an amazing resource. You will find all kinds of things. You will find literary works, you'll find music, you'll find pictures, you'll find short films. So if you're looking for a work to use, if a faculty member comes to you, say, with a picture of a cheetah that they found in a stock photography site and said, I want to use this, can I use it? Well, consider fair use, or can we find a Creative Commons licensed photograph of a cheetah that they could use instead? So moving on to the next slide, please. Another option in front of you is using open access works. Open access works are pretty close to Creative Commons works. They are scholarly resources, a lot of times research articles or scholarly books that have been freely available online and are licensed for reuse. As librarians, we know how much we pay for our databases. There's that paywall in place so that our patrons can get access to those particular works. And with those licenses that we enter into to acquire those works for our patrons, sometimes there are restrictions on reuse. With open access works, as long as you act within the scope of the license, which is usually providing credit to the journal and the original author, you are generally free to reshare those works with other people. It's kind of dependent on each open access journal or each open access article or work. You can learn more about open access through Spark. They're a great resource, or you can go to the Directory of Open Access Journals to look for open access journals and journal articles. If we can move on to the next slide, please. So seeking permission, reach out and ask for permission. If what you want to do does not fall within the scope of fair use, identify the rights holder, Reach out to them, preferably in writing via email, and say, hi, I'm a copyright librarian, or I'm working with this faculty member here at my institution, helping with a copyright question. They want to reuse your work, and we want to see if we can get your permission to do so. The Columbia Copyright Office has some really great information on how to go about these permissions requests. One fun permission story I want to share with you is that about a year and a half ago, I was working with a faculty member who had been using a documentary that she found online. The documentary was legally posted online. It had been put up there by the rights holders, and it took a look at microloans in developing countries and the way that they were helping women establish their own businesses. She went to go use the video in class, and she found out the video was gone. It had been taken down when they were doing some routine maintenance on the website. She called me in a little bit of a panic because the video was a core part of her teaching that particular lesson. I hopped onto the Internet Movie Database. I looked up the producers and the director, and I sent them all emails. I said, hi, I'm Carla Myers. I'm a copyright librarian. I'm working with this faculty member. She had been using this documentary you had posted online. It is no longer there. Can you sell a copy to my library? Or would you give us permission to post a digital copy within the content management system so that students can watch this and talk about it in class? The same day, which is pretty quick as far as permissions requests go, I got the loveliest email back from one of the producers. And he said, I am so excited that this is being taught in class and it's being used this way. And I posted the documentary to Vimeo, and here's the password to access it. Please only share the password with students in this class. And oh, by the way, do you think the faculty member would be interested in me Skyping into the class and talking about my experience producing this movie and working with these women? And so not only did we have a really positive resolution to the whole situation, they got access to a copy of the movie, but the course instructor was so delighted to have them Skype in as a special guest for one of the sessions. So consider permissions requests. It's very rare that I get a no when I seek a permission. If we can move on to the next slide. And then another option that is always available to you is licensing. These are just a few of many of the licensing organizations that are out there. A license usually involves paying a fee to use a particular work in a very particular way for a particular amount of time. And one question that always comes with licensing is who is going to pay the licensing fee? Will it be the faculty member? Will it be their department? Will it be their school? Will it be the library? So licensing is an option, but because of the financial considerations, there might be some things you have to think about. If we can move on to the next slide. So how do we put this all together? Here are my recommendations. Moving on to the next slide. I think first and foremost, it is so important to remember our mission. Do not ignore the law. It will not go away. Don't think that because I'm a library or educational institution or this is an educational situation, we don't have to think about copyright. You very much do. But do not let fear of being sued keep you or your faculty from taking advantage of the exceptions found in the law. Or don't let fear of being sued keep you from providing services to faculty. I think I had mentioned earlier that I spent most of my career working in a library circulation department. And anybody who works in circulation will tell you accidents happen within the library. It could be a rainy day and a patron walks in and slips water that dripped off somebody's umbrella. It could be that somebody tripped and fell down the stairs. It could be that somebody went to pull a book off a high shelf, and because the shelf was packed so tightly, they pulled one book down and 3 other books came down and dunked them on the head. Accidents like these happen in libraries, and truthfully, the library could be sued for any of those situations. But you know, I think if an administrator ever came to us as librarians or came to a library staff and said, you know, people could get injured in our building, and we could be sued for that. I think we need to shut our doors so nobody comes in here and nobody gets injured when we have eliminated that risk of being sued. I like to think that not only the staff in that library, but librarians everywhere would rise up and say, no, that is so against our mission. Our mission is to be here, to have our doors open, to be a gathering spot for our patrons. Our mission is to provide them with good quality information. And there are things we can do to mitigate risk. We can make sure that we mop up spills. We can put those sticky things on steps so people don't fall down them so easy. We can make sure our bookshelves aren't so full that things fall off and hit people on the head. But we're not going to close our doors just because we might get sued. And I would encourage you to think of U.S. copyright law in the same capacity. If somebody says to you, oh, we shouldn't offer those services, we shouldn't help with these because we might get sued, Well, I would respond, yes, we might get sued, but we can study the law. We can put factors or policies into place that can help us mitigate risk. We can work with our campus attorneys to make sure that we're acting in compliance with the law. So that way, if we are ever questioned and find ourselves in court, we can put forward to the judge or the jury, here is how we thought we were acting within the scope of our law, and here are our policies and practices that really strike a balance between the rights granted to copyright holders in the law, but also the rights granted to users and these exceptions. If it gives you a little bit of peace of mind, you can actually find this language in Section 504C2 of U.S. copyright law. And basically what it says is that if you are an employee of a not-for-profit educational institution or library and you are found guilty for infringing copyright when utilizing fair use, those scary statutory damages, the ones where you're hearing millions of dollars for one particular song, those go away. Instead, we'll focus more on a reasonable license fee. So as long as you can prove that good faith intent, either through checklists that you use or sound copyright policies, you do have this statute written into the law, which provides a little bit of relief. So moving on to the next slide, please. My recommendations moving forward, educate yourself about copyright law and fair use. Seize every opportunity you might have to learn more about the law from quality resources, from people who are knowledgeable. Go to conference presentations, read good books written about the law. Work with your colleagues and administrators and the attorneys at your institution to develop a sound game plan for how you're going to handle these questions and what your copyright policies might be. And another great thing you can do is provide copyright education for your own patrons. Offer a session on the copyright basics. Offer a session on fair use in the classroom and how faculty can utilize it. Put quality information on your website that the faculty can get to. And then moving on to the next slide. I'm going to skip over these scenarios for the sake of time. You can take a look at these later. These are just common scenarios that I hear or that I get asked a lot because I'm a copyright librarian. And if you move on to the next slide, again, I'm just going to kind of leave these here for you to review at a later time. These are going to be quality educational tools and resources that you can use to learn more about the law, learn more about fair use, or use in providing fair use consultation services. So I am now ready for questions. Thank you all for being such a good sport with a little technical difficulty we had and staying over a little bit late.
Yes, thank you, Carla, and thanks for everyone for kind of rolling with our little tech hiccup there. And we'll see how many of questions we can get through over the next 10 minutes or so. So I'll just kind of move through the list. So our first question is asking, is copying a work which is under copyright but out of print fairly permissible through e-reserves if a professor adopts it as their course textbook?
Oh, so it depends, and all my fellow copyright librarians are laughing at me right now because it depends is the answer to a lot of questions. So I would say work through the 4 factors of fair use. Something else you might be able to consider here is Section 108. If something is out of print, considering making a copy for the library to use within the library. So the reason I suggest that is I had a similar situation a while back. I had a faculty member who was interested in reusing a book. It was out of print. There were 2 copies for sale on Amazon, maybe 3 or 4 copies, but either way, when you have that few copies, they're all for sale for $200 each. 108. This is the kind of question that is sometimes difficult for copyright librarians to answer, especially within the context of this presentation, because this might be a slightly more risky situation. I'm not saying that you can't consider fair use, but I think this is one, if the faculty member brought it to me, that I would want to talk with my legal counsel to make sure they were on board with what I wanted to do moving forward.
Thanks, Carla. And sorry again that we keep losing you. We'll do a few more questions here because I know we're kind of really getting over time. But we had a person ask, she said, recently I had a faculty member ask me if she could show short clips of a TV show for a presentation. I said yes because it seemed to be a clear fair use case. Then she said she wanted to remove commercials from the clips, which would have required making a copy, then editing it. Obviously, making copies is prohibited, but what if it's for the purpose of fair use? What would you have told her?
So I would have said it depends. So one thing I want to clear up there is making copies is prohibited if it's not a fair use or if it doesn't fall under one of the other exceptions. So a lot of times with fair use, we are looking to make copies, and if what you're doing, making that copy falls within the scope of fair use, then there are protections there. So my first question probably would have been, where are you getting the clips from? Are you pulling them off the station's website? Are you pulling them off of YouTube? Have they been posted legally to YouTube? Are they clips from a TV show or a movie that the library could get a copy of the DVD and then pull the clips from that? So I think it would depend a little bit on where they were getting those clips from, but I don't think you were wrong at all to tell them that they could certainly consider fair use in that situation.
All right, another question here. We recently borrowed a VHS tape from one of our professors for his research. He could not view it and at his own initiative and expense had it transferred to a DVD. When he was done, he offered to give it to us to add to the library collection, parenthetical, we refused, or to give it to the loaning library, parenthetical, we also refused. But could we have done either of these?
So it depends. When you are looking to acquire, well, let's start at the beginning. So transferring VHS into a new medium, like DVD or digital, that's something that's on a lot of people's minds right now, or I should say a lot of librarians' minds, because they don't make VHS players anymore. So what do we do with these VHS collections that we have? As an individual, this faculty member on their own prerogative, they could consider fair use for transferring a VHS to a DVD. Now, one thing for them to think about as part of that fair use analysis would be, what is the effect on the market? If that DVD is for sale and I'm making my own DVD copy of this work, I could be impacting the market for the original. If a faculty member approached me and said, you know, I had this in VHS, I made a DVD, I would like to donate it to the library for whatever reason they were looking to donate. I think my response would have been, thank you so much for thinking about the library. Tell me a little bit about this film. Do you use it often? Do you think other people would be looking to use it? I would emphasize our general donation policy. And then as part of that donation practice, what I would take a look at is generally, what do we do with donations? And if we're considering really adding this to our collection, can we buy a lawful copy? Is there a DVD copy available that the library can purchase? Is there a digital copy that we can buy streaming access to? If the answer is yes, that's something I personally would seriously consider. If it's something we desperately want to add to our collection, but there are no VHS or DVD copies, there are no DVD or streaming copies available, then I think you could consider integrating that into your collection, taking a look at it as a very rare item and something you might want to preserve or hang on to for future use.
Thanks. We'll try to get through just a few more questions here. So another question that came in is asking if it is a historic protected building, can the image ever be protected? What about a photo of a public piece of sculpture?
So generally the way it works with things like sculpture in buildings is they are out in the public. So taking a picture of them, taking photographs of them, generally that's okay. Now, when it comes to sculpture, and some of my fellow copyright librarians who are in on this call might want to weigh in on this particular question. Buildings don't concern me maybe sometimes as much as sculpture does. I think it's one thing if you're walking through Central Park and you're like, oh, look at that amazing sculpture of Balto. I want to take a picture of it so I can just have a picture of it for my own personal use. It might be another thing if you said, I'm going to take pictures of all these sculptures to use to create a calendar and then start selling those calendars. It's a little questionable to each situation, but if you're taking pictures of historical buildings or sculpture for your own personal enjoyment and use, I personally don't have a lot of concerns with that.
Thank you. And unfortunately, we're not going to get through all of our questions. We'll wrap with this one. And just a reminder, we'll be sending out the recordings and other resources as well. So Carla, kind of the last question for this afternoon is, what do you think is the best way to advertise to faculty that you are here to help answer their copyright fair use questions? We have a hard time getting the word out here.
Sure. I would say utilize your coworkers. The subject librarians who work directly with faculty, they can say, hey, do you know we now have somebody on our staff who's answering copyright questions? Go to events, introduce yourself as a copyright librarian, utilize programming. See if you can get a write-up in an email newsletter or write up a short story on your library webpage talking about these services. Most people are very excited that there's a copyright resource on campus and they're eager to talk with you. It really is what you said, getting the word out there about your services. And I would say utilize every option you can find in front of you to try to get the word out and try to engage with your faculty.
Great. Thanks again, Carla, for being with us today. Thanks for hanging in there with us for a few of those tech issues. And I'd like to thank everyone for being part of our webcast today. Have a great afternoon, everyone.
Thank you.